Picture this. It is midnight on a completely deserted stretch of highway.
Okay, setting the scene.
Right. And a police officer spots a car with a busted taillight, so, he flips on the sirens.
Pretty standard stuff.
Exactly. The car pulls over, the officer walks up, taps on the glass, and asks the driver for their license and registration.
Right, it's like the most routine interaction in the entire American legal system.
Literally the most routine. But instead of, rolling down the window and handing over a plastic ID card, the driver slides this piece of heavy parchment through a tiny crack in the glass.
Oh, boy. A parchment.
Yeah, parchment. The officer shines a flashlight on it, and it is not a driver's license.
Let me guess.
It is a homemade, quote-unquote, international traveling permit.
Right. Of course it is.
And the driver just announces that they are a living man and that they are traveling under the diplomatic protection of a 1787 maritime treaty with Moroccan pirates.
Wow.
So therefore, the police officer has absolutely no jurisdiction over them.
It sounds like an internet prank, right?
Yeah, it really does. Or like a very niche sketch comedy routine.
Yeah, exactly. But the wild thing is, interactions exactly like that one are playing out on highways and in courtrooms and, at county clerk offices across the country every single day.
Every single day, which is it's mind-boggling.
It is. And while it's really easy to just dismiss it all as fringe behavior, the underlying impulse actually touches on something incredibly profound.
Right.
Because it forces us to ask a question that has basically haunted the American legal system since its inception.
Which is?
What actually happens when a state or a county or even just one individual, looks the federal government dead in the eye and says, no, your laws do not apply here.
And that is exactly what we are exploring in this deep dive.
That's a huge topic.
It is massive. We are tracing the exact microscopic legal boundary between legally ignoring the federal government because, spoiler alert for you listening, there are situations where you actually can do that.
Yes, there are.
Right. So the boundary between that and crossing the line into active seditious obstruction. We are basically looking at the ultimate constitutional rebuttal to what you might call homemade sovereignty.
Right. And the tension at the heart of this entire exploration, the thing you have to keep in mind, is the gap between paper and reality.
The enforcement gap.
Exactly. Because on paper, like inside the walls of a courtroom, the federal government has an unbroken 200-year winning streak.
An undefeated record.
Undefeated.
Yeah.
Against every single form of nullification and homemade sovereignty, the legal arguments are just crushed every time.
But out in the real world.
Right. Out in the real world, there is a massive, incredibly dangerous difference between a judge's gavel falling in a silent, secure room and a federal agent trying to actually enforce that ruling out on a dirt road.
Especially when the people staring back at them completely refuse to acknowledge the judge's authority in the first place.
Exactly. That is where things get incredibly volatile.
So that gap, the gap between legal supremacy and practical enforcement, that is where the real stakes are. But to really understand why the rules of this game are written the way they are, we have to rewind the clock.
We really do.
We have to go back to the exact moment the architects of the country realized their very first attempt at building a nation was basically a catastrophic failure.
This is a disaster.
So take us back to the 1780s. The Revolutionary War is won, but the country is operating under the Articles of Confederation. What was actually happening on the ground?
Total systemic dysfunction. I mean, we tend to romanticize the founding era, right?
Sure, powdered wigs and noble debates.
Exactly. But under the Articles of Confederation, the national government was essentially a polite suggestion box.
A suggestion box?
Yeah, they had a legislature, but they had absolutely no enforcement mechanism. None.
So they couldn't actually make anyone do anything.
Right. They could request troops for defense. They could, request funds to pay off the massive crippling war debts they had just incurred.
Which were huge.
Enormous. But they had zero power to actually bind anyone to those requests.
So let me get this straight. If the national government sent a bill to the state of New York saying, hey, we need your share of the debt payment this month, New York could just, what, ignore it?
They didn't just ignore it, they actively refused.
Wow.
The states basically treated the national government like a charity they occasionally felt like donating to.
That is wild.
It was. The national government was functionally bankrupt. I mean, they couldn't pay the soldiers who had literally just fought the revolution.
Which is a recipe for a mutiny.
Absolutely. And they were internationally embarrassed because they couldn't uphold treaties. European powers were looking at this new experiment and literally placing bets on how quickly it would collapse.
It's essentially the geopolitical version of, like, a terrible group project in college.
That's a great way to put it.
Right. You have a designated leader who is supposed to put the presentation together, but there are zero consequences if the other group members just decide to go to the beach instead of doing the research.
Exactly. The leader can't fire them. They can't dock their grade.
They just have to sit there completely powerless and watch the entire project tank.
That is exactly the dynamic. The states were acting as completely independent sovereign nations that were only really allied when it was convenient for them.
So something had to change.
Right. So when the delegates convened in Philadelphia in 1787 to draft what would eventually become the Constitution, they knew they had to fix this specific fatal flaw.
They needed teeth.
They had to create a mechanism that ensured national law actually meant something. And their solution was tucked right into Article 6, Clause 2.
What we now call the Supremacy Clause.
Exactly.
Okay, let's break down the actual text of that clause because I know the phrasing they chose is so deliberate.
It's incredibly precise.
So it says that the Constitution and the laws of the United States shall be the supreme law of the land. Now that part makes sense. You're just establishing a hierarchy, right?
Right. Federal on top.
But the next sentence is what I find fascinating. It explicitly says that this supreme law binds the judges in every state, anything in the Constitution or laws of any state to the contrary notwithstanding.
And that right there, that is the linchpin of the entire American legal system.
But wait, let's unpack this. Why single out the judges?
What do you mean?
Well, why not write this binds the governors or this binds the state legislatures or, I don't know, the sheriffs? Why aim this ultimate power directly at the local judicial branch?
That is a great question. It's because the founders intimately understood the mechanics of how power is actually wielded day to day.
Okay, how so?
Well, a state legislature can write whatever they want on a piece of paper.
Right.
And a governor can stand on a soapbox and give all the fiery speeches they want. But laws are ultimately interpreted, applied, and enforced in courtrooms.
Right, the rubber meets the road with the judge.
Exactly. By forcing state judges to swear an oath to the federal Constitution, and by explicitly stating that federal law overrides state law in their specific courtrooms, they structurally disabled local governments from legally turning against the national one.
Wow. Wait, let me make sure I'm following this. They basically bypassed the politicians entirely.
Yes, completely bypassed them.
They embedded federal loyalty directly into the state's own machinery.
Precisely. Think of it like a biological immune system.
Okay.
If a state legislature gets some wild idea and passes a law that directly contradicts a federal statute, the founders designed the system so that the state's own judges are constitutionally required to strike that state law down.
So the federal government doesn't even necessarily have to send an army to stop the state.
No, the state's own courts are programmed to reject the state's defiance.
That is brilliant. It's like an override code built into the operating system.
It really is. And they defended this design vigorously. If you look at the debates from that era, specifically Alexander Hamilton in Federalist 33 and James Madison in Federalist 44,
The heavy hitters.
right, they argued that this clause was the literal difference between a functioning government and a mere treaty between neighbors.
Because without it, you're just back to the group project.
Exactly. Hamilton pointed out that if national laws aren't supreme, then you don't have a nation. You just have a temporary alliance that exists only as long as everyone feels like playing nice.
Which isn't very long in politics.
Not at all. But, and this is a massive but, there is a crucial qualifier in the text of the Supremacy Clause.
Right. It says federal laws are only supreme if they are made in pursuance of the Constitution.
Exactly. In pursuance. The federal government cannot just pass any wild, tyrannical law at once and automatically declare it the supreme law of the land.
Right. They don't have a blank check.
Exactly. The law has to actually fall within the enumerated powers granted to the federal government by the Constitution.
And enumerated powers just means the specific list of things the Constitution explicitly allows the federal government to do, right?
Yes. Like regulating interstate commerce or coining money or declaring war.
So if a law falls outside that list, it's not in pursuance of the Constitution.
And therefore, it is not supreme.
Which naturally is exactly where the battle lines are drawn today. I mean, anyone who wants to defy the federal government just claims, well, your law is unconstitutional, therefore it's not supreme, therefore I don't have to follow it.
Yes, that is the exact argument. And that brings us to the very first massive real-world test of this machinery.
Let's get into it.
Because Writing "We are supreme" on parchment in Philadelphia in 1787, that's easy.
Right, paper is patient.
But actually enforcing it decades later when a sovereign state looks you in the eye and openly defies you, that is another story entirely.
So let's look at how this played out in the real world. We are jumping forward to 1819. The country is growing, the economy is getting complicated, and we get a landmark Supreme Court case. McCulloch v. Maryland. Set the scene for us here. Why was Maryland so angry in 1819?
It all centered around the Second Bank of the United States. Congress had chartered this national bank to help control the currency and manage federal funds.
Makes sense.
But state-chartered banks hated it. They viewed the federal bank as a massive, unfair competitor.
Because it's muscling in on their territory.
Exactly. It was restricting their own ability to issue loans and print money.
Yeah.
So the state of Maryland decided they were going to do something about it.
What did they do?
They passed a law imposing a massive tax on any bank operating in Maryland that wasn't chartered by the Maryland legislature.
Oh, wow. Which is a very thinly veiled laser-guided missile aimed directly at the Baltimore branch of the federal bank.
Completely. The tax was specifically designed to be so punitively high that the federal bank would either have to pay up and go bankrupt or pack up and leave the state entirely.
I have to say, this is such a clever strategy.
It really is.
Because they aren't raising a militia, they aren't declaring war on Washington, they are just using tax policy. It's nullification by ledger.
Nullification by ledger. I like that.
They are basically saying, sure, the federal government has the right to exist, but we control the geography, and we are going to make the cost of your existence so impossibly high that you are functionally destroyed within our borders.
It was a very sophisticated attack on federal supremacy.
Yeah.
So the head of the Baltimore branch, a man named James McCulloch, simply refused to pay the tax.
Naturally.
Maryland sued him, and the case went all the way up to the Supreme Court, which was led at the time by Chief Justice John Marshall.
And Marshall delivered a ruling that essentially became the foundational operating code for American federalism, right?
He did.
So what was his logic? How did he untangle Maryland's trap?
Marshall wrote one of the most famous lines in Supreme Court history. He wrote, "The power to tax involves the power to destroy."
The power to tax involves the power to destroy.
Right. He reasoned that if a state is allowed to tax an instrument of the federal government, they can control it. And if they can control it, they can scale that tax up until they destroy it.
Right, because if Maryland can tax the federal bank, what's to stop them from taxing the federal mail?
Exactly, or taxing the federal courts. Or the customs house.
So if you concede the premise that a state can tax a federal entity, you concede the supremacy of the federal government entirely.
That is exactly the point Marshall made. He ruled that because the Constitution is supreme, states cannot control, burden, or destroy federal instruments.
Period.
Period. As long as the federal government is acting within its constitutional powers, which Marshall ruled, the creation of the bank was federal supremacy is absolute.
So Maryland's tax was struck down.
Struck down. The ledger loophole was officially closed.
Okay, but shutting down an accounting trick is one thing. It doesn't take long for the defiance to get much louder and much more direct.
Well, not long at all.
Because just over a decade later, in 1832, we hit the Nullification Crisis.
Yeah.
And this is where we have to talk about Vice President John C. Calhoun. Because the theory he popularizes during this crisis is it's basically the intellectual grandfather of almost every homemade sovereignty movement we see today.
It really is. Calhoun championed what is known as the compact theory.
The compact theory, what does that mean?
His argument was that the United States was not a single, indivisible nation created by the people. Instead, he argued that the Constitution was essentially a compact, a treaty agreed to by sovereign states.
Okay, let's unpack this compact theory for a second. Because if the states are the ones who created the treaty, what does that mean for federal power?
Well, in Calhoun's mind, it meant the states were the ultimate bosses.
Okay.
If the states created the federal government, then the federal government is merely an agent of the states. Therefore, the states, as the creators of the compact, have the ultimate final right to judge when their agent has overstepped its bounds.
So if the federal government passes a law and a state decides that law is unconstitutional,
the state can simply declare the law null and void within its own borders.
wow, that is a complete inversion of Article 6.
Total inversion.
It's saying the state is supreme over the federal law, and South Carolina actually decides to test drive this theory in the real world, don't they?
They absolutely did. Congress had passed a series of federal tariffs taxes on imported goods that heavily favored northern manufacturing but severely hurt the southern agricultural economy.
Right. The South relied on cheap imports.
Exactly. South Carolinians literally called it the Tariff of Abominations.
Tell us how you really feel.
Right. So in 1832, South Carolina held a state convention and formally adopted an ordinance of nullification.
They just went for it.
They went for it. They declared that the federal tariffs were unconstitutional and therefore legally void within the state of South Carolina. They explicitly forbade the collection of those duties within their state.
They just openly dared the federal government to do something about it.
They drew a line in the sand.
Now, the president at the time is Andrew Jackson. And Jackson is such a fascinating figure here because politically, he was a massive states' rights advocate.
He was.
He was a Southern plantation owner. You would think, looking at him on paper, he might be sympathetic to South Carolina's position.
You really might think so.
Hmm.
But Jackson's response was absolutely nuclear.
Really?
Oh, yeah.
Yeah.
He viewed nullification not as some, polite legal debate, but as a direct threat to the survival of the United States.
Wow.
He issued a blistering proclamation to the people of South Carolina, completely dismantling Calhoun's compact theory. He declared that nullification is incompatible with the existence of the Union.
Strong words.
And he did not mince words about the consequences. He warned them, in writing, that disunion by armed force is treason.
That's not a subtle threat.
No. And he didn't just write a stern letter either. He backed it up with legislative muscle.
What did he do?
He went to Congress and demanded the passage of what became known as the Force Bill.
The Force Bill.
Yes. This legislation explicitly authorized the president to use the United States military to collect the tariff revenues in South Carolina.
Oh, wow.
He was effectively saying, you won't collect the tax? Fine. I will march the federal army down there and collect it myself at bayonet point.
And South Carolina blinked.
They blinked. They realized no other southern states were going to join them in an armed rebellion at that particular moment, so they backed down, repealed the nullification ordinance, and the crisis ended.
But I want to pause on Jackson for a moment here, because it's so important to look at the reality of enforcement.
Right.
Jackson threatened military force to crush nullification when it threatened federal tax revenue.
Yes, he did.
But around the exact same time, he was involved in a massive failure of federal supremacy regarding the Cherokee Nation.
It is one of the starkest examples of the enforcement gap in American history.
Break that down for us.
While Jackson was threatening South Carolina with the Army, the Supreme Court, again under John Marshall, was dealing with a crisis in Georgia. In a case called Worcester v. Georgia, the Supreme Court ruled that the state of Georgia had absolutely no constitutional authority to impose its state laws on sovereign Cherokee territory.
Because they had a federal treaty.
Right. The federal treaty with the Cherokee was supreme.
So legally, the Supreme Court tells Georgia, you have to back off. Federal law protects the Cherokee.
Yes. But Andrew Jackson deeply desired the removal of Native Americans from the Southeast to open up land for white settlement.
Right.
So when the Supreme Court issued its ruling protecting the Cherokee, Jackson functionally ignored it.
Wow.
The famous quote attributed to him is, "John Marshall has made his decision, now let him enforce it."
Which is such a chilling realization. The Chief Justice of the Supreme Court doesn't have an army.
No, he doesn't.
He doesn't have a police force. He just has a pen.
Exactly. And whether Jackson actually uttered those exact words is debated by historians, but the reality of the outcome is undisputed.
Right, the outcome is what matters.
The federal executive branch, under Jackson, simply refused to use its power to enforce the Supreme Court's ruling against the state of Georgia.
It perfectly illustrates the fragility of the system. Supremacy works against South Carolina because the president is willing to point cannons at them.
Yes.
Supremacy fails for the Cherokee because the president simply chooses to look the other way.
The mechanism only works if the people in power are willing to actually turn the gears.
Wow. Okay, let's keep moving through our timeline, because we hit a case in 1859 that provides what is arguably the ultimate moral stress test of the Supremacy Clause.
This is a heavy one.
Yeah, this is Ableman v. Booth.
Right. This case is deeply uncomfortable to study, but it is structurally essential if you want to understand how blind the mechanism of supremacy truly is.
Okay, tell us about 1859.
So in 1850, as part of a political compromise to keep the South from seceding, Congress passed the Fugitive Slave Act.
And just to clarify for you listening how draconian this law was, it didn't just allow slave catchers to cross into free states.
No, it went much further.
It actively required citizens in free states to assist in the capture of escaped slaves. and it imposed massive penalties on anyone who helped a slave escape. It essentially deputized the entire North into enforcing slavery.
It was a horrific piece of legislation.
Mm-hmm.
And in Wisconsin, an abolitionist named Sherman Booth decided to actively defy it.
Good for him.
Right. He helped organize a mob that broke into a jail and freed a man named Joshua Glover, who had escaped slavery and been captured by federal marshals.
Incredible.
But Booth was subsequently arrested by federal authorities for violating the Fugitive Slave Act.
But this is where the state of Wisconsin steps in, right? And they don't just protest, they use their state judicial system to attack the federal government.
Yes, they do. The Wisconsin state courts were packed with anti-slavery judges. So when Booth was arrested by the federal government, the state courts issued writs of habeas corpus.
Let's define that term for a second. What does a writ of habeas corpus actually do in this context?
Habeas corpus translates to, "You shall have the body." It is a legal order demanding that a prison official bring a prisoner before the court and legally justify why that person is being held. If the state cannot prove a lawful reason for the detention, the prisoner must be released.
So the Wisconsin state judge is demanding that the federal marshal prove why Sherman Booth should be in a federal cell.
Exactly. And the Wisconsin Supreme Court went even further.
Yeah.
They looked at the Federal Fugitive Slave Act and unilaterally declared it unconstitutional.
Just struck it down.
Yes, they ordered Booth freed. And when the federal marshals arrested him again, the state court ordered him freed again.
They are just playing tug of war.
Yeah, exactly. Wisconsin was effectively nullifying a federal law within its borders, using its state courts as the weapon.
This is such a profound knot to untangle, because morally, I think we can all agree, Wisconsin is entirely on the right side of history here.
Absolutely. The Fugitive Slave Act was an abomination.
But structurally, from the perspective of constitutional mechanics, Wisconsin is doing the exact same thing South Carolina tried to do with the tariff.
It is the exact same mechanism.
They're a state deciding they can override the federal government.
And that is exactly how the Supreme Court viewed it when the case finally reached them in 1859.
Who was the Chief Justice then?
It was Roger Taney.
Ah, the same man who authored the disastrous Dred Scott decision.
The very same. And Taney completely rejected Wisconsin's actions. He ruled that state courts have absolutely no authority to override federal judgments, to interfere with federal prisoners, or to nullify federal law.
So the supremacy of the federal government held firm, even for a terrible law.
It held firm. And it's a brutal reality check on how the system operates. The Supremacy Clause doesn't have a moral compass.
Right. It is just a strict, impartial mechanism.
It has to be. Think about it. If the Supreme Court had allowed Wisconsin to successfully establish the legal right to nullify federal law, they found morally objectionable.
Right.
That exact same legal mechanism would have become precedent. And a decade later, Southern states would have used that exact same mechanism to nullify the 13th, 14th, and 15th Amendments.
Oh, wow. Yeah. Or federal civil rights legislation.
Exactly. You cannot build a constitutional loophole that only works for the good guys. The system has to reject the mechanism of nullification entirely, regardless of the cause.
Wow. That is a sobering point. Of course, just a couple of years after Ableman v. Booth, the intellectual debate over the compact theory ended in the most catastrophic way possible.
That's Civil War.
Right. From 1861 to 1865, the ultimate question of whether a state could unilaterally exit the Union or override federal authority was settled.
And it was settled not by gavels and parchment, but by force and blood. The Union victory permanently cemented the reality that the nation is indestructible and federal supremacy is absolute.
The compact theory was basically dead on the battlefield.
Dead and buried.
But the ghost of nullification didn't stay buried forever.
Yeah.
We see it violently reemerge almost a century later during the Civil Rights Movement. Let's look at 1958, Cooper v. Aaron.
Yes, this is a monumental case.
Okay.
This is the aftermath of Brown v. Board of Education, where the Supreme Court ruled that racial segregation in public schools was unconstitutional.
Right.
In Little Rock, Arkansas, the state government, led by Governor Orville Faubus, vehemently opposed desegregation. Faubus actually deployed the Arkansas National Guard to physically block black students, the Little Rock Nine, from entering Central High School.
Which forced President Eisenhower to federalize the National Guard and send in the 101st Airborne Division to escort the students.
Yes, it's an incredible escalation.
An absolute showdown. But the legal fight didn't end there, right?
No, it continued in the courts. The Little Rock School Board asked for a delay in desegregation, arguing that the intense public hostility and the state government's defiance made it impossible to safely integrate.
And the state's legal argument was essentially, we don't agree with the Supreme Court's interpretation of the 14th Amendment in Brown v. Board, and we are a sovereign state, so we aren't bound by it.
Exactly. Arkansas is basically trying to resurrect John C. Calhoun. We don't agree with the referee, so we're ignoring the whistle.
How did the Supreme Court handle that in Cooper v. Aaron?
They delivered a response that is almost unprecedented in the history of the court.
Really? What did they do?
All 9 Supreme Court justices individually signed a single unanimous opinion.
Wait, individually signed it? Why is signing it individually such a big deal? Doesn't the Chief Justice usually just sign the majority opinion?
Usually, yes. But by having all 9 justices affix their individual signatures, they were sending an undeniable, unified message to the governors and state legislators of the South.
A show of absolute force.
Exactly. They were saying, there is no division here. You cannot nullify federal law. And crucially, they declared that the Supreme Court's interpretation of the Constitution is the supreme law of the land, and every state official is bound by it.
Okay, I want to push back on that specific phrasing for a second, because I can hear the constitutional scholars yelling at their speakers right now.
Oh, absolutely.
Because Article 6 says the Constitution is supreme. It doesn't explicitly say the Supreme Court's opinion of the Constitution is supreme.
Right, that's a very fair point.
So when the court declares that its own interpretation is infallible and binding on everyone, isn't that crossing the line from constitutional supremacy into judicial supremacy? Do critics have a point there?
It is a very sharp distinction, and you are tapping into a massive ongoing academic debate known as departmentalism.
Departmentalism.
Yes, departmentalists argue that all 3 branches of the federal government, the executive, the legislative, and the judicial, have a co-equal right to interpret the Constitution for themselves within their own spheres of duty.
Okay, give me an example of that.
Sure. For example, a president can veto a law because they believe it's unconstitutional, even if the court hasn't ruled on it yet.
So under departmentalism, the Supreme Court isn't the sole ultimate dictator of what the text means.
Correct. However, and this is the crucial distinction, while legal scholars love to debate the nuances of how much interpretive power the Supreme Court has relative to the president or to Congress,
Right.
absolutely no respected version of this debate licenses a state governor to unilaterally nullify federal law.
Okay, that makes sense.
The hierarchy established by the Supremacy Clause remains intact. The debate is about horizontal power among the federal branches in Washington, not vertical power allowing states to defy Washington.
That's a great way to put it. Horizontal versus vertical. So if we look at the scorecard from 1787 to 1958,
Let's review it.
the founders specifically hardwired the state courts to reject defiance.
Yeah.
John Marshall crushed the ledger loophole in McCulloch.
Yeah.
Andrew Jackson threatened an army to crush the compact theory. The Civil War ended secession, and the Warren Court unanimously shut down state-level defiance of civil rights.
The verdict is a brick wall. Nullification loses. Every single time.
From the governor's mansion, yes.
Yeah.
But by the 1960s, state governments largely stopped trying to formally nullify federal law because they realized it is an unwinnable battle.
Right.
But the impulse to defy the federal government didn't vanish, did it?
No, it just decentralized.
It shrank down. If the state can't claim sovereignty, then the county will try. If the county can't do it, the individual will try. And that brings us to the modern era and what we're calling the 3 pillars of homemade sovereignty.
This is where things get really weird.
Very weird. People are still walking into courtrooms today trying to bypass federal law, but they are using incredibly bizarre, highly specific legal theories. Let's break down how modern judges systematically dismantle these arguments, starting with Pillar 1, the jurisdiction counter.
Okay, so this is the most common argument you see in those viral traffic stop videos we talked about earlier.
The sovereign citizen movement.
Right. The core belief here is that there is a difference between the physical, flesh and blood human being, what they call the living man,
The living man.
and the artificial corporate legal entity created by the government when a birth certificate is issued. They often call this the strawman.
Right. They believe the government is actually a corporation, and if they never consented to a contract with that corporation, or if they formally revoke their citizenship paperwork, the laws simply don't apply to the living man.
That is the theory, yes.
I've even seen videos where they argue with judges that because the American flag in the courtroom has gold fringe on it.
Oh, the gold fringe argument, yeah.
Right. They say it's actually an admiralty court, naval court, and therefore has no jurisdiction over someone on dry land. How does a judge even begin to untangle that web of conspiracy?
They don't. That is the beauty of the judicial counter.
they just ignore it?
The courts do not engage in philosophical debates about social contracts or the definition of a living man or the gold fringe on a flag. The court's counter is devastatingly simple.
Which is?
Jurisdiction in the United States is territorial, not contractual.
Territorial, not contractual.
Yeah.
What does that mean in plain English?
It means the law applies to you because of where your physical body is located, regardless of what you believe or what paperwork you haven't signed.
It's just geography.
Exactly. State appellate courts, and there's a massive genre of these cases. For example, a long string of appeals out of Georgia. They flatly dismiss these claims. They rule that if you are physically standing on the geographic dirt of a specific state and you break a law within those borders, the police power of that state applies to you.
It's the ultimate reality check. You can't just opt out of the speed limit by telling the police officer you unsubscribe from the state's terms of service.
Exactly. You're driving on their road. You are subject to their rules.
So territorial jurisdiction completely neutralizes the contractual argument.
Completely. Which forces these individuals to look for a different loophole.
Mm-hmm.
If they can't beat the judge on physical geography, they need a law that actually trumps state law.
And according to the Supremacy Clause we've been discussing, what is the supreme law of the land?
The Constitution, federal laws.
And treaties.
And treaties, yes.
Which brings us perfectly to Pillar 2, the treaty counter. And this one is wildly specific and deeply confusing the first time you hear it.
Is very strange.
People go into court and claim they don't have to pay taxes or they can't be arrested because they are protected by the 1787 Treaty of Peace and Friendship with Morocco.
Yep.
I have to admit, when I first read this in the source material, I genuinely thought it was a typo.
A lot of people do.
How on earth does a treaty with 18th century Morocco come up in a modern zoning dispute in, like, Ohio?
It is a fascinating mutation of legal history. Adherents of certain groups, like the Moorish Science Temple of America or various Moorish sovereign groups, believe that they are the descendants of indigenous Moors.
Okay.
And they argue that because Article 6 makes treaties the supreme law of the land, this 1787 treaty grants them a form of diplomatic immunity or sovereign status.
Meaning what, exactly?
Meaning they believe it exempts them from U.S. taxation and local criminal law.
Okay, let's play along for a second. The Constitution does say treaties are supreme. We established that. So what is the flaw in their argument? What was the 1787 Treaty of Morocco actually about?
Well, the courts accept the constitutional premise. Yes, treaties are the supreme law of the land. But a treaty is only supreme regarding the specific subjects it covers, and only between the sovereign nations that signed it. Okay, so what did this one cover? The 1787 Treaty of Peace and Friendship was a bilateral maritime commerce agreement.
Maritime commerce. So ships.
Yes. Its primary purpose was to protect American shipping vessels in the Mediterranean Sea from being attacked by Barbary pirates.
Oh, wow. Okay.
It established rules for trade, ship inspections, and what to do if an American ship was captured. It had absolutely nothing to do with domestic land ownership, local zoning laws, or individual criminal immunity inside the borders of the United States.
So someone is literally standing in a municipal court in New Jersey trying to use an agreement designed to stop pirates off the coast of North Africa
Yes.
to get out of paying a speeding ticket.
That is exactly what is happening. And federal courts, in cases like the Marrakesh Caliphate case, universally crush this argument.
I would imagine so.
They rule clearly that the treaty confers no domestic immunities whatsoever to individuals living inside the U.S. today. It is a fundamental misreading of both international law and the text of the treaty itself.
Okay, so individual jurisdiction claims fail. Treaty claims fail. That leaves us with Pillar 3, the property counter.
Right.
And this shifts our focus from individuals back up to the county level, specifically out west, where the federal government owns vast tracts of land. What is the argument here?
Well, in many Western states, the federal government, through agencies like the Bureau of Land Management or the Forest Service, owns 50, 60, sometimes over 80% of the land in a given county.
Over 80%. That is huge.
It is massive.
Yeah.
And this creates immense friction over grazing rights, mining, and land use.
Naturally.
So over the years, various counties have attempted to pass local ordinances declaring that they have ultimate supremacy over all the land within their borders.
Okay, and they're saying the federal government cannot permanently hold land without the state's consent.
Exactly. And they base this on the 10th Amendment, right?
Right, the 10th Amendment. The idea that any power not explicitly given to the federal government is reserved for the states.
Right. So their logic is if the Constitution doesn't say the federal government can own half of Nevada,
All right.
then the federal government can't own half of Nevada.
Seems logical on the surface,
Yeah.
but how do the courts handle it?
When these county supremacy cases hit the federal courts, the judges never even reach a discussion of the 10th Amendment.
They don't. Why not?
They don't have to, because the Constitution has another clause that completely overrides it. Article 4, Section 3, Clause 2.
Okay, what is that?
It's known as the Property Clause.
The property clause, what does it actually say?
It explicitly grants Congress the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States.
Okay, so Congress makes the rules for its own property.
Right. And the Supreme Court has interpreted this power as absolute. In a 1976 case called Kleppe v. New Mexico, the court explicitly stated that Congress's power over public lands is without limitations.
Without limitations, that doesn't leave much wiggle room for a county commissioner.
None at all. And this was tested directly in a very famous 1996 case, United States v. Nye County.
What happened there?
Nye County in Nevada essentially passed resolutions asserting ownership and control over federal public lands, openly challenging federal authority.
Just claiming it for themselves.
Exactly. The federal government sued the county, and the court ruled decisively against Nye County.
Using the property clause.
Right. The property clause means the federal government can own, regulate, and manage land within a state, and a county has zero legal authority to seize it or overrule federal regulations on that land.
Wow. Okay, so let's summarize the courtroom reality here.
It's pretty bleak for the sovereignty movement.
Right. States cannot nullify federal law. Individuals cannot magically opt out of territorial jurisdiction. 18th century maritime pirate treaties do not excuse you from property taxes.
No, they don't.
And counties cannot seize federal land. The courts have a bulletproof, mathematically precise legal counter for every single homemade sovereignty argument. It seems like the federal government's power is absolute and inescapable.
But here is where we reach the crux of the entire deep dive.
Okay, hit me.
Everything we just discussed involves someone trying to actively override or defeat a federal law.
Right, trying to win the fight.
But what if local officials don't want to fight the federal government? What if they don't claim they have the power to stop Washington?
Yeah.
They just completely refuse to help.
They just sit on their hands.
Exactly. That introduces a massive, completely lawful loophole. And it brings us to the crucial boundary between passive non-cooperation and active obstruction.
This is the legal needle we have to thread. How does a local sheriff legally ignore the federal government?
To understand this, we have to look at a pivotal 1997 Supreme Court case. Printz v. United States.
Printz v. United States. What is the background here?
It's about the Brady Handgun Violence Prevention Act, which was a federal law requiring background checks for firearm purchases.
Okay.
But the federal government didn't have enough agents to run all these checks, so the law explicitly commanded local county law enforcement officers, specifically a sheriff named J. Printz, to perform the background checks on behalf of the federal government.
Wait, so Congress essentially drafted local sheriffs to do federal paperwork.
Exactly. They conscripted them. And Sheriff Printz sued, arguing that the federal government cannot force state officers to administer a federal regulatory program.
And what did the Supreme Court say?
The Supreme Court agreed with him. They established what is known as the anti-commandeering doctrine.
Anti-commandeering, let's make sure we really grasp this. It's like, well, let me try an analogy. It's like the CEO of a massive parent company suddenly telling a local independent franchise manager, hey, we just instituted a new, highly controversial dress code for all customers.
Okay, I'm with you.
And you and your cashiers have to enforce it for us, but we aren't going to pay you extra to do it. And the local manager can look at the CEO and say, no, if you want that rule enforced in my store, send your own corporate security guys down here to do it. I'm not doing your dirty work.
That is a perfect analogy. The federal government has the power to enforce its own laws using its own federal agents. The FBI, the DEA, the ATF, the marshals.
Right.
But under the anti-commandeering doctrine, they cannot conscript state or local resources to do it for them. A local sheriff or a city police department can lawfully engage in passive non-cooperation.
So, I won't help you is a constitutionally protected stance.
Yes, it is. For example, during the 2014 standoff at Bunkerville in Nevada, which we'll discuss more in a moment,
Right.
when the federal government arrived to impound cattle, they asked the local sheriff, Sheriff Gillespie, for assistance. Gillespie largely declined to involve his deputies in assisting the federal operation.
He just stayed out of it.
And legally, under Printz, he was completely within his rights to say no.
Okay, this is fascinating because if passive non-cooperation is legal. Let's look at how this plays out in modern politics, because this is everywhere right now.
Oh, it's a huge issue today.
Let's look at this entirely neutrally, strictly through the lens of constitutional mechanics. You have progressive sanctuary cities that pass ordinances refusing to use local police to assist federal ICE agents with immigration enforcement.
Right.
And on the flip side, you have conservative counties declaring themselves Second Amendment sanctuaries, passing resolutions refusing to use local police to enforce federal gun control laws.
Yeah.
Structurally, are they doing the exact same thing?
Yes. Legal scholars refer to this as sanctuary symmetry.
Sanctuary symmetry.
Both left-wing immigration sanctuaries and right-wing Second Amendment sanctuaries are standing on the exact same legal foundation. The anti-commandeering doctrine established in Printz.
What?
As long as a progressive mayor or a conservative sheriff is practicing strict passive non-cooperation, simply saying, we will not use local tax dollars, local jail space, or local officers to assist your federal operation, the courts generally consider that lawful.
That is such a clarifying way to look at it. The mechanism is completely politically neutral.
It is.
But what is the limit? When does a sanctuary city or a constitutional sheriff cross the line from legal non-cooperation into something illegal?
The line is crossed the moment passive refusal turns into active obstruction.
Okay, break that down.
It's the difference between step 1 and step 2. Step 1, I won't help you enforce this law. That is lawful federalism.
Right.
Step 2, I have the authority to stop you from enforcing this law in my county. That is illegal sedition.
Give me an example of what step 2 looks like in practice.
Okay, if a local sheriff says, I won't help the ATF confiscate these weapons, that is fine. If that same sheriff says, if an ATF agent crosses the county line, I will have my deputies physically block their vehicles, or I will arrest the federal agent for trespassing.
Oh, wow.
They have crossed the Rubicon. The moment a local official tries to actively penalize, physically block, or arrest a federal officer operating within their jurisdiction, they're violating the Supremacy Clause.
They become the obstacle.
Exactly. That claim of authority to stop the federal government has lost in every court, in every era, under every political alignment in American history.
So, I won't help is protected, I can stop you is sedition. That is the exact boundary line.
That is the line.
And inside a courtroom, that line is crystal clear. The federal government's supremacy is legally overwhelming. But we don't live inside a courtroom.
We do not.
We live in the messy physical world. And winning the argument on paper doesn't always translate to winning on the ground. Which brings us to the final and frankly most unnerving part of this deep dive, the enforcement gap.
This is where the friction of reality grinds against the elegance of legal theory.
Right.
The courts have dismantled every sovereignty argument, but courts don't magically enforce their own rulings. A judge signs an order, but a human being has to go out and execute it.
And when people deeply believe that the court has no authority over them, they react in incredibly destructive ways.
Yes, they do.
And one of the ways they react doesn't even involve physical violence initially. It involves what is sometimes called the fraud crush or paper terrorism.
Paper terrorism.
How does a sovereign citizen attack the system using paperwork?
They basically weaponize bureaucracy. It often happens during foreclosures or tax disputes. An individual will file what they call an allodial title on a property.
Let's define that. What is an allodial title, at least in their minds?
Well, in medieval property law, allodial land is land owned absolutely, free of any duties or obligations to a lord or a sovereign.
Okay.
Sovereign citizens have revived this ancient concept. They believe that by filing a specific sequence of homemade legal documents, they can convert their property into allodial land.
Meaning what?
Meaning they believe the bank cannot foreclose on it and the state cannot tax it.
But the courts obviously don't recognize that.
They don't. But when the bank or the county tries to proceed with the eviction, the individual will bury the legal system in an avalanche of incomprehensible pseudo-legal filings.
Just gumming up the works.
Exactly. They will file fraudulent quitclaim deeds, and worse, they engage in retaliatory filings.
What does that mean?
They will look up the names of the judges, the clerks, and the police officers involved in their case and file massive, completely fake commercial liens against their personal property.
Oh my God. So a local clerk who is just doing her job suddenly finds out she has a $5 million lien on her house and her credit is destroyed.
Exactly. It's designed to terrorize public officials into backing off. And the system has had to adapt.
How do you even fight that?
Judges don't sit there and debate the nuances of medieval allodial titles. Prosecutors simply charge the underlying conduct. They charge these individuals with forgery, grand theft, and even racketeering.
Wow.
States have literally had to pass specific, targeted laws criminalizing the filing of retaliatory liens against public officials just to protect their own employees.
It's an administrative nightmare. But there is a much more volatile flashpoint where the friction of reality becomes physically dangerous.
Yes.
And it takes us right back to the scenario we opened this deep dive with. The routine traffic stop. Why is a traffic stop so incredibly dangerous when it involves someone who believes in homemade sovereignty?
Because the two people involved in that interaction are operating in completely different realities.
Different reality.
Yes.
Yeah.
To the police officer, they are simply enforcing a state motor vehicle code. They want to see a driver's license.
Right.
But to the adherent of a sovereignty movement, the state is an illegitimate corporate entity.
Right.
They believe they have an absolute God-given right to travel.
Yeah.
They draw a sharp distinction between driving, which they define as engaging in commercial activity on the roads,
Okay.
and traveling, which is their fundamental right as a living man.
So when the officer asks for a license,
The individual views it not as a legal request, but as an illegitimate corporate assault. They refuse to roll down the window. They refuse to identify themselves. They hand over homemade international traveling permits.
right.
And because they believe the officer has zero jurisdiction, they feel entirely justified in physically resisting.
And what should have been a 5-minute interaction and a $50 fine for a broken taillight rapidly escalates.
They go south instantly.
The officer demands they step out of the car. They refuse. The window gets broken. Tasers are deployed. It turns into a felony arrest for resisting and assaulting an officer.
Exactly. The escalation mechanics are terrifying
Yeah.
because neither side can back down. The officer has to enforce the law, and the driver believes they are defending their literal freedom against a tyrant.
The human cost is just devastating. You have individuals ruining their credit, losing their homes, going to federal prison, or being injured or killed on the side of a highway.
All because they deeply bought into a legal fantasy about a 1787 maritime treaty or a misunderstanding of territorial jurisdiction. The consequences of believing you are immune to the law are catastrophic when reality finally catches up to you.
What happens when reality doesn't catch up?
That's the scary part.
What happens when a group is large enough and heavily armed enough that local enforcement simply decides the cost of enforcing the law is too high?
This is the ultimate expression of the enforcement gap. And the defining modern examples of this are the armed standoffs in the American West.
Right.
Specifically, the standoff at Bunkerville, Nevada in 2014, and the occupation of the Malheur National Wildlife Refuge in Oregon in 2016.
Walk us through the mechanics of Bunkerville, because based on everything we just learned today, the federal government had absolute legal supremacy there.
Absolutely. A rancher had refused to pay federal grazing fees for decades, claiming the federal government didn't have the right to own or manage the land.
But we know how that goes.
Right. The federal courts looked at the property clause and completely ruled against him. They issued court orders authorizing the Bureau of Land Management, the BLM, to impound his cattle. Legally, it was a closed case.
Well, when the BLM agents actually showed up in the desert to collect the cows?
They were met by hundreds of armed supporters, including militia groups who had traveled from across the country. They took up sniper positions on highway overpasses. They physically blocked the federal agents.
Wow.
It was a massive, heavily armed standoff.
And as we established earlier, the local sheriff practiced passive non-cooperation. She didn't send his deputies in to clear the crowd.
Right, so the federal agents were on their own, staring down hundreds of rifles. And the federal officials made a calculation.
What did they do?
Rather than risk a massive bloodbath over grazing fees, the Bureau of Land Management retreated. They stood down, released the cattle they had gathered, and left.
Wait. The federal government had the Constitution, they had the Supreme Court precedent, they had the property clause, they had the legal order,
Yes.
and they surrendered the field.
They did. And 2 years later, at Malheur, in Oregon, armed individuals physically occupied a federal wildlife refuge for over a month.
Right.
And while that occupation eventually ended with arrests and one tragic fatality, when the leaders of the occupation were brought to trial in federal court, a jury acquitted them of the primary conspiracy charges.
A jury acquitted them.
Yes. The prosecution struggled to clearly communicate the legal complexities, and the defense managed to introduce enough confusion or perhaps tap into enough local sympathy that the jury refused to convict.
So, winning the constitutional argument on paper on a Tuesday means absolutely nothing if the federal agents are forced to retreat on a Thursday and a jury refuses to enforce the law the following year.
Exactly.
Yeah.
And the ripple effects of that enforcement gap are profound.
I can imagine.
Federal land managers today literally have to plan their daily operations, routine things like repairing fences or surveying water lines around the fear of armed backlash from local residents who have internalized these sovereignty theories.
That is wild.
The law says the federal agents are supreme. The reality on the ground dictates that they act with extreme caution.
It's an incredible paradox. Which brings us to the grand conclusion of this entire deep dive.
We have covered a lot.
We have covered an immense amount of ground. We started in the ashes of the Articles of Confederation in 1787, where the founders engineered Article 6 specifically because a government without a supreme law isn't a government at all.
Right.
We watched John Marshall protect the federal ledger in 1819, and Andrew Jackson threaten military force against South Carolina's compact theory in 1832.
We saw the Warren Court unanimously, with 9 signatures, shut down state-level defiance during the Civil Rights era.
We mapped how modern judges effortlessly dismantle territorial arguments and pirate treaty claims.
And we found the exact, precise legal boundary between the constitutionally protected right to passively refuse to help and the illegal sedition of actively obstructing a federal agent.
The legal structure is a fortress. It is unbroken.
It is.
But the reality is that the supremacy of the Constitution is not a physical law of nature. It's not gravity. If you drop an apple, it falls. If a judge strikes down a law, nothing physically happens in the real world unless human beings decide to make it happen.
That is so true.
Yeah.
The Constitution's supremacy is ultimately a promise.
A promise.
And it is a promise that is kept entirely by institutions. It is kept by judges who are willing to rule impartially. It's kept by federal marshals who are willing to serve the process. It is kept by local sheriffs who understand the limits of their authority.
And crucially, it is kept by juries who are willing to convict based on facts rather than ideology.
Exactly. Where those institutions are robust, supremacy is absolute. But where those institutions are thin, intimidated, or where public sympathy overrides the text of the law, supremacy persists on paper, but it goes utterly quiet on the ground.
That is deeply sobering. And it leaves us with one final vital question to ponder for you listening as we wrap up. The entire system of constitutional supremacy, the whole 200-year experiment, ultimately relies on a very fragile psychological contract.
It relies on citizens voluntarily accepting the loss of their own arguments.
Right. When you go to court and you lose, you have to agree to abide by the referee's ruling, even if you hate it.
If supremacy isn't self-executing, what happens to the fabric of the law when a critical mass of people simply decide they no longer accept the referee's call?
Even without firing a single shot, without a standoff in the desert, how long can a paper promise survive if the institutions backing it lose the belief of the public?
That is the big question.
That is the thought we want to leave you with today. The law is only as strong as the collective will to uphold it. And whether you are reading a piece of parchment drafted by James Madison or staring down a dark dirt road in Nevada, that gap between theory and reality is where history is actually written.
Well said.
Thank you so much for joining us on this deep dive into the source material. Keep questioning the world around you. Keep looking for the mechanisms behind the headlines. And remember, the next time you feel the instinct to just opt out of the rules, things are rarely as simple as they seem. Sometimes the waters are deeply, deeply murky.